Article 6, Office of Oil, Gas Wells, Administrative Enforcement, West Virginia. Chapter 22, 6, 1, Definitions. Unless context is used clearly requires a different meaning. With the article, casing means strings of pipes commonly placed in wells drilled with natural gas or petroleum or both. Cement means hydraulic cement properly mixed with water. Chair means a chair with a West Virginia Shallow Gas Well Review Board is provided in Section for Article 8. For Section 4, Article 8, Chapter 22 of this code, coal operator means a person with a person, firm, partnership, association, corporation, purposes to operate the coal seams, work bed, coal bed, interchangeable to teams, mean with a seam with a coal of 20 inches with more thickness, and less seams less in thickness being commercially work can be in judgment with the Department of Forestry, commercial work well protection will require protection of the wells drilled through it. The direction means with the direction of the Division of Environmental Protection established in Article 1 of the chapter, such of the persons to whom the director of the delegated authority duties pursuant to Section 6 of the 8 of the Article 1 of the chapter. Deep well means with well with shallow well drilled with complete with formation at with below with the top of the uppermost part of the Ondaganda group. Expanding cement means with cement with a proof with the office of the oil with the gas expanding with the drilling with the hardening process with included but not limited to regular oil field cements proper additive facility that means a facility utilized with the oil and gas industry shape specifically named that refers to the article 8 or 9 in chapter other well or well size gas all of the natural gas all fluid hydrocarbon does not define any oil in this section. Oil means with the natural crude oil or petroleum other hydrocarbons regardless of the gravity which are produced well with liquid form with the ordinary production methods with which are not result of the condensation of the gas with either ever leads underground reservoirs. Owner, while when used in the reference to any of the wells shall include any of the person, firm, partnership, the partnership, association, corporation, or that owns, manages, operates with control of the possesses well with the principal of lease of the contractors employed with the agent. Such principals, owners, review with the reference to the coal seam shall include any of the person who lease if they operate such coal seam person means any of the natural purpose corporation firm and a partnership, association, venture, receiver, trustee, executive, administrative, the guardian, fiduciary of the other representative of any of the kind, includes any of the government to any of the political subdivision of any agency thereof. Plat means a map of the drawing printing showing the location of the wells here in the defined. Review board means West Virginia Shallow Gas Well Review Board provided for this section for Article 8, Chapter 22 of this code. Safe mining through the well means mining of the coal, workable coal bed up to which with the penetrate with the touch of the work bed coal through with the touch of the well, so with the casting of the well, plug of the well bore which will penetrates workable coal bell is served shallow well means a gas well drill with complete with the formation above the top of the uppermost part of the Ondaganda group provided with drilling shallow well of the operator may penetrate with the Ondaganda group of the responsible the depth of it except the 22 feet in order to allow the logging completion operation, but in no event the Ondaganda group formation otherwise produced with the perforated stimulated in any manner. Stimulated means of the action of taking the well operator to increase the inherent productivity of the oil and gas well, including but not limited to fracturing, shooting, aciding, but excluding cleaning out of the bailing walkover operations. Waste means physical fate and waste, but it's a term that is generally understood with the oil and gas industry. 2. Locating, drilling, equipping, operating, producing an oil gas well in a manner that causes tendency to cause the substantial reduction in the quantity of the oil and gas, ultimately recovery from the pool of the prudent proper operations, or that causes the tendency to cause the substantial unnecessary excessive source loss of the oil of the gas. And 3. Drilling of more depths well with the responsible required to recover efficient economically the maximum amount of oil gas from a pool. 4. Substantial inefficient effective with improper use for the substantial unnecessary dissipation of the reservoir energy understood with nothing in this chapter shall be construed with the authorized agency state with the impose with the mandatory spacing of the shallow wells except for provision section 8 and article 9 of chapter 22 with its code provision article 8 of the chapter 22 of this code insufficient storing oil and gas provided storage in accordance with certificate public conveyance issued with the Federal Energy Regulatory Commission should be conclusively presumed efficient. 6. The underground surface of water with the production, storage, oil, and gas condensate, however, cause, which is not included, but gas vented with the release any mine areas defined within Section 2, Article 22 with this code adjacent with the coal seam with the subject current permit issued with the Article 2, Chapter 22 with the code provided, however, that nothing in this exclusion intended to address ownership of the gas well means any shaft hole sunk or drilled bored water the drug into the earth underground strive with the extraction, injection, replacement, liquid gas, any shot hole sunk with the U of the conjunction, such extraction, injection, placement, trim well does not include any shaft, hole sunk, drill, bored, dug into the earth, the sole purpose of oil drilling, pumping, extracting for these air from potable, fresh, usable waste for the household, domestic, industrial, agricultural, public use. Well work means with the drilling, with the re-drilling, with the deepening, with the stimulating pressure, with the injection, any fluid, converting with the type of the well, with doing with the combining physical change, with allowing with the mitigation with the fluid from the one formation to with another, plugging, repelling, plugging any well with the well operator, with the operator meaning with the person, firm, with the partnership, associate with the corporation, purpose that does, with the locate, with the drill, with the operator, with the abandon, any well here is defined. X pollutant shall have the same meaning with the provided in subsection 17, section 3, article 11, and chapter 22 of this code. Y waters of the chase shall have the same meaning with the waters provided in section 23 of the section 3, article 11, and chapter 22 of the code. 2262 with the director of the power duties, generally the division record with the public inspect, with the director shall have his or her with the duty, supervision, execution, and enforcement of the matter of the related with the oil and gas set out with this article 8 with the 9 of the chapter of the director with the as authorized to enact rules necessary to evaluate above stated purpose of the director with the full chart with the oil and gas matter set out with the articles 8 with the 9 of the chapter in addition with all the other powers duties conferred upon him. The director shall have the power to duty supervise the divide with the activities of the office of the oil and gas for the purpose set forth with the subsection A and B with sections carried out. Employee supervising oil gas inspector, oil gas inspectors. Supervise the direct such oil gas inspector supervising inspector the performance of the duty to suspend with the good cause of any of the oil gas and inspector, supervisor, inspector without the compensation with a period of the not exceeding 30 days of the calendar year of the prepare a report with the form of the oil and gas inspector, supervisor, inspector with the making the finding order with the notice for the upon inspection with the according to articles 11, 8, and 9 intended chapter, employing hearing officers such clerks, stenograph, the other employees of the necessary with the carry out with the duties, purpose of the office and oil gas fixed with the compensation here determined applying with the made with the owners and the well operator, coal operators, and nominally with a revision of the old orders made by the oil and gas inspector, supervising inspector to make inspection with the in accordance with the provision articles in articles 8 and 9 of this chapter. 8 cause properly with the index permit with the public record to keep all of the inspection made with the director of the oil and gas inspector with the supervising inspector. 9 conduct such research and study with the director shall deem necessary to aid with the protecting the health and the safety of the person employed with the potential existing oil and gas production fields within the state with the improve with the drill with the production method to provide more efficient protection with the preservation of oil and gas bearing rock strata properly with the connection thereof, with the collecting with a permit over the $250 for each of the permit application provided with no permanent application fee shall be required for the applicant submitted solely with the plugging and replugging with the well. All applications required here under shall be in addition with any other fees required with the provision of the article 11 perform all the duties within expressly imposed upon the director provision with the chapter 12 perform all the duties permitting issue with authority state within all the matters pertaining exploration, development, production, storage, recovery of the state and oil and gas. 13 adopt rules that respect the issue with the denial of the retention, suspension, revocation of the permits authorization requirements of the chapter of the rules and shall assure with the rule permits authorization issued by director adequate for safety purposes of the article 7, 8, and 9 and 10 of this chapter with the particular with respect to the consolidation of various state with the federal programs which place permitting requirements of exploration, development, production, storage, recovery of the state and oil and gas provided not notwithstanding any provision of the articles 7, 8, and 9 and 10 of this chapter. The contrary with the Environmental Quality Board shall have the sole with authority provisions pursuant to section 3, article 2 and 3 of the chapter 22 with the B with the promulgate with the rules setting standard with the water quality applicable with the waters of the state. 14 performing such acts as the necessary with the appropriate to serve with the state with the benefit of the federal legislation establishing programs relating to the exploration, development, production, storage, recovery with the state and oil gas, which programs assumed by the state. D the director which shall have the authority to visit with the inspector any of the well site with any other oil gas facilities state may call assistant of the oil and gas inspector with the inspector, supervising inspector, whenever the such with the assistance of the necessary inspection of any such well with the well site with any other oil and gas facility similar all of the oil and gas inspector with the supervising inspector shall have the authority to visit, inspect any well site, any other oil gas facility in the state. As a well operator with a coal operator operating coal seam beneath the track of the land with a coal seam owner and leaser, if instead of the owner and leaser of the not operating said with the coal seams beneath the track of the land may require the director to have immediately immediately inspection made by the operative, the owner of every well of the well site with any other oil gas facility shall cooperate with the director or oil and gas inspector, supervisor, and inspectors making inspection with obtaining information. Oil and gas inspectors should devote full-time and divided attention to the performance of the duties and shall be responsible for the inspection of all well sites other than the oil and gas facilities in their respective districts. Often may require for the performance of the duties. All records of the office shall be open to the public. 2263, finding order with the inspector with the concern with the violation, determination, responsible for the abatement with the extension of the time of abatement, special inspection, notice of the finding and orders. If an oil with a gas inspector with the upon with the making of the inspection well with the well site with any of the oil and gas with the find with the provision with the article with the violated with the inspector shall also find well with the not any with the imminent danger of the person exists whether the not exist the imminent danger of the fresh water source or supply well containing loss. Inspector find with the imminent danger exists the other in order to requiring the operator shall as such well with the well sites other than any oil and gas facility with the cease further operation which until the imminent danger of the shall be issued with the inspector find with the imminent danger exists. Inspectorship would be a reasonable period of time which such violation would be totally abated if the such findings contained with the reference provision with the article with the inspector finds and with being violated detailed restrictions of the condition which cause the constitute such violation. A period of time is found with such oil and gas inspector with a reasonable period of time shall not exceed 7 days. Such period with extent with such of the inspector or by any other oil gas inspector duly authorized by the director time to time with the good cause not exceed with a total of 30 days upon the making of the special inspection assertion whether the not such violation is totally abated, provided that such 30-day period extended with beyond the 30 days period, such the inspector of abatement shown to be incapable of the accomplishment because circumstantial of the condition beyond the core control of the well operative of the director shall cause for the special inspection to be made whenever the operator well site with any other oil gas facility prior to expiration of such period with the time when the quote for the director cause for the special inspection to be made with such well site any other oil with gas facility be upon expiration of such period of time originally fixed extended unless for the director is satisfied with the violation has been abated. Upon making such special inspection, such oil and gas shall be determined whether or not such violation has been totally abated. If the inspector determines such violation has not been totally abated, the inspector will determine whether or not such period of time originally fixed, extended, shall be extended. If the inspector determines if such period of time should be extended, the inspector should determine the reasonable extension would be. If the inspector determines such violation has not been totally abated, such period of time with originally fixed, extended, expired, the inspector determines such for the period of the time should not be further extended. The inspector thereupon the order requiring the operator such for the well site with the oil gas facility see for the further operations such well site facilities as the case may be. Such finding for the order shall with the reference and specific provisions of the article without which are being violated. Notice each of the finding order may be section shall promptly be given to the operator of the well site with the oil and gas facility which for the permit pertains to the person making such of the finding order. No order will be issued with the authority in section will not access or expressly authorized herein. Section 2264 of the reviewing findings orders directive of the special inspection and annulment the provision etc. of order and notice. Any well operator complaining coal operator owner or lease of the fifth degree by the findings order of the made by the oil and gas inspector pursuant to section 3 of this article may within 15 days apply with the director and annulment the revision such order with the receipt of the applicant with the director shall make a special inspection of the well site with the other oil gas facility affected such order with the cause of the duly authorized oil with the gas inspector the other oil and gas inspector whose such order supervisor inspecting only duly authorized gas inspector the other than the oil gas inspector shall be made such order to make such the inspection such well site with the other oil and gas facility to report there on to them upon making such special inspection upon receipt of the report special inspection of the case of the director shall with making an order shall include with the director finding the shall annul provides affirming the order of the oil and gas. Expect for the director shall call for the notice of each of the finding other made with this section with given the property to operate well site other gas facilities to such finding to the other water pertaining to the complaint under section 3 of the if any at any time with the when and while in order it may pursuant to section 3 of this article the operator of the well site with the oil and gas facility affected such order may apply with the director and normal revision such order. Director will thereon proceed to act with the application manner provided in this section in view of the urgent with a prompt decision submitted by the director on this article. All actions director, oil, gas inspector, supervising, or inspector are required to take under this article should be taken rapidly, practically, as consistent with the adequate consideration issues involved. 2265 requirements finding orders notices posting finding orders judicial review final orders director. All finding orders made pursuant to 3 and 4 of this article. All notices required given of the making such findings and orders shall be written. All such findings and orders shall be signed for the person making such notice and signed by the person charged with the duty of the given with the notice. All such notices contained with a copy of the findings orders referred to therein. Notice of finding order required by Section 3 and 4 of this article to be given the operator shall be given the cause of such notice addressed to operator as well. Over the well site, other oil, or other gas facilities, such finding order pertaining to the delivered such operative with the cause and copy thereof to be sent with a registered mail with a permanent address, such operative with the file with the division causing the copy thereto with the posted with the drilling, rigging, other equipment at well site, other oil, gas facilities, and as the case may be, the requirement of the article's notes with the address of the operator's well site, other oil, gas facilities to which such finding order pertaining shall not require with the name of the operator from what intended specifically set out with addressing such notice as the operator of blank, specifying the well site, and other and gas facilities sufficient to identify such satisfy such requirement. Alright, any well operator complying with the coal operator, owner, and lease with it in order to be addressly effective with the final order issued with none of the section of the article with the entitled with a judicial review thereof, all of the pertinent provisions, Section 4, Article 5 of the Chapter with the 29 with the scope which shall apply with the governing such for the judicial review effective with the provision, said Section 4, were set forth in extenso with the section. The judgment in circuit court shall be finally, unless reversed, evaluated with a modified with the appeal Supreme Court with appeal with the accordance with the provision, Section 1, Article 6, Chapter 29 of the Code of the Legal Counsel services with the directive to apply when the proceed with any of the Circuit Court with the Supreme Court appeals shall provide with the Attorney General of his or her assistant with any of the Circuit Court with the prosecuting or attorney with the county as well without additional compensation of the director with the written approval of the Attorney General that may employ special counsel for the representative of the director at any such appeal for the proceeding. 2266 for the permit required for the well work permit fee application soil erosion control plan. It's unlawful for any person to commence all well work, including site preparation work, that involve the disturbance of the land without securing the director of the well work permit. Application may be the proposed of the permanent may approve of the two or more activities to define as work while. Application work permit should be over the company with the applicable bond prescribed with Section 12, 1433 of the article with the applicable flat required with the Section 12 of the 14 of this article. Every permit application filed within the section verified shall contain the following: the name and address of one with the well operator, two with the agent required with the designated with the subsection E with the Section 3. Every person with the applicant must notify with the under section article that together with the certification evidence of the copy of the application, all of the required documentation should be delivered in such all of the person. The name and address of the coal operator operating coal seam of the under the track of the land, which for the well with the may be the located coal seam operator with the record with the lease for the record required with the give of the notice filed with the Section 12. If any said owner of the lease or with the not yet with the oil operating soil said coil seams, number of the well, such for the other identification of the director may require with the type of the well work with the permit is requested, the approximate depth of the well with the drill with the deep end of the actual depth of the well with the been drilled, and 7, any permit application fee required by law. 8, if the proposed well work will require casing tube setting with an inch of the casing of the program for well, including side with each of the string pipe with the starting part of the depth of which each string is to be set, extent from which each such string is to be cemented. If the proposed well work is convert an oil well combination well with a drilled new well for the purpose of introducing pressure for the recovery of will provide Section 25 of this article specification according to the data requirements in Section 14 of this article. 10 for the proposed well work with the plug to replug with the well specification according to the data requirements Section 23 of this article. A copy of the logs and operative of the possession of the director may require the 3 of the work order for the detail of the proposed man with the plugging and unplugging the well in order. Representative of the director for the interest of the person may represent the work is done in the event of the applicant drill with the re-drill with the deepening of the well work contest so the well must be planned and plugged and abandoned. If the well one of the well work continuously progressing pursuant to the permit, operator may pursue to plug it as well, assuming the operator obtained with the verbal permission of the director designated representative of the plug abandoned well, except for the operator shall make a reasonable effort to notify himself of the prudent soon as practical surface operator with the coal owner if any of the land well location as so shall also timely file with a plugging affidavit required with the Section 23 of this article. 11. If the proposed well work stimulate oil and gas well specification according to the data of the requirement Section 13 of the article, erosion and sediment control plan required in subsection D with the section applicant with the permit to drill. Any other relevant information for the director may require the rule. An erosion sediment control plan shall accompany each of the applicants of the well work permit except for the well work permit to plug with a replug any well. Such plan with the containment of method stabilization drainage included map of the project with the indicated with the amount of the acreage disturbed disturbed erosion sediment control plan shall meet with the minimum requirements of West Virginia erosion sediment with the control manual with adopted from time to time, amended with the division, consultant with the several soil with the conservation district, pursuant with the control program and establishment of the state through Section 208 Federal Water Pollution Control Act amended in 1972 with erosion sediment with the control plan shall be part of the terms of the condition well work permit except with the well work permit plug replug any well which is issued with the provision of this plan carried out with the applicable operation erosion sediment control plan shall be set with the proposed method. Reclamation should comply with the requirements of the Section 30 of this article. Well, the operator name and such for the application shall designate with the name and address of the agent such for the operator's well shall be an attorney in fact for the operative with the shall resident with the state of West Virginia upon with a notice and order with the communication issued pursuant to the article or article 11 in chapter 22 with the may be served upon with the process that may be served. Every well operator required with the designated with the agent within the section shall within 5 days of the termination such for the designation notified with the director shall with the designated with the new agent. Well, owner and operator shall instead of the permanent numbers issued with the director with the legibly with a permanent number manner of the well on the completion of any permitted work that mentions specification manner and installation in accordance with the rules of the director. The director may waive the requirements of action within the section of the 9 and 10 and 11 of this article. Emergency situation director deems such necessary, but instead of the director may issue emergency permit which would affect for not more than 30 days, which would be subject to reissuance of the director. The director shall deny issuing with the permit. The director determine the applicant with a committee with a substantial violation of the previously and issue with the permit, including erosion sediment control plan with a substantial violation, one or more of the rules promulgated to hereunder to fail to abate with the seek the review of the violation with the time prescribed by the director pursuant to the provision of the section 3 and 4 of this article with the rules promulgated to hereunder but the time that may not be unreasonable provided that in the event the director does find with a substantial violation occurred with the operator have then failed to abate and seek with the review of the violation with the time prescribed. The director may suspend with a permit of such violation exhibited after suspension of the operator forthwith cease all of the well work being conducted with under the permit provided however the director reinstate with the permit further the notice which of the time of the well work may be continued with the director shall make written finding for the sub of the termination may enforce same in with the circuits of the courts of the state where the operator may apply with an such suspension pursuant with the provision of section 40 of this article. The director shall make a written finding with the sub of the termination. Any of the person who violates the provision section guilty with a misdemeanor upon conviction thereof shall be fined no more than $55,000 in prison with the county jail, no more than 12 months with the bill fine within prison. Alright, 2267, the water pollution control permits of powers and due with the director. Penalties in addition to the permit of well work for the director after the public notice of the opportunity for the public hearing with the may issue with a separate permit with a general permit consolidated with a well work permit for discharge disposition pollutant with a combination of the pollutants in water of the state with upon with the condition such discharge disposition meets will meet all applicable state and federal water quality standard with the effluent and liquids of the all other requirements of the directive. It should be unlawful for the person conducting activity subject to the requirements of the article unless the person holds the water pollution control permit thereof the director which is in full force in effect to allow pollutants effluent within produced emanating with any of the point source to flow in the water of the state. 2 may cause on the permit to made with the outlet with the substantial and large added load with existing with the outlet discharge pollutant with the effluent with the from the waters of the state with acquire, construct, install with the modified with the operator disroll with the system purchasing with the direct and indirect discharge with the deposit with the treated untreated pollutant effluent therefrom and into the water of the state with the extensive addition with the such of the disposal system. Agree with the volume and concentration pollutant with the extract of the discharge of the disposition specified and permitted under an existing permit, extend with the modified at any of the addition points over the operation which would cover the increase of the volume of the concentration, any of the pollutant discharge flowing within the waters for the state, operating any of the disposal of the well with an injection and re-injection underground with any pollutant included with the down liquid gas to convert any of the well to such with the disposal of the plug in addition, any with the disposal of the not seen with any of the provision article 7 and 8 and 9 with the 10th chapter of the contract with the director shall have the power and the duties relating inspection enforcement with the granted under Article 11 of Chapter 22 of the Code connection with the issue with any of the water pollutant control with a permanent person required to have such permit, any of the person violated with the provision section, any of the order issued or with any of the permit issued with the pursuant section, and of any rule of the director relating to the water pollutant with the who willingly, negligently violates the provision section, any permit issued with the pursuant section, any of the rule ordered with the director relating to the water pollution who fail with the refuse to apply for the obtained permit and intentionally with the misrepresent any material fact with the application recorded report plan and other document files required to be maintained under the section subject with the same penalty with the violation provided with the section 22 to 24 with the article with 11 and chapter 22 with the code, provided that provision section 22.6 article 11 chapter 22 of the code relating extension of the criminal liability shall also apply. All applicants in injunction filed with the pursuant Section 22 of the Article 11 Chapter 22 of this code shall take with the priority docket of the circuit court with the pending which shall take the precedence over all of the other civil cases. Any water pollution control permit issued with the pursuant of this section in order to issue connection stuff with the permit that purpose for the implementing national pollutant discharge elimination system established in Federal Clean Water Act shall be issued and Chief of the Officer for the Water Resource of the Division, consultant with the Chief of the Officer for the Oil and Gas Division, shall be appealable with the Environmental Quality Board pursuant to the provision of Section 25 of the Article 11 and Chapter 22, Section 7 and the Article 1, Chapter 22b of this code. 2268. Permits not to be flat well royalty leases of the legislative findings declaration permit requirement. The legislature hereby finds that the declare that the significant portion of the oil, gas, underlying state of the subject of the development and pursuant of the lease for the other continuing with the contractual agreements wherein the owners of such oil and the gas are paid upon with royalty rental based for the dome with the industry with the annual flat well royalty based with the royalties based solely on the extra for the producing oil but is not inherently related with the volume of oil, gas produced and marketed, continued exploration of the natural resource of the state with the exchange with the sole hold of the inadequate compensation unfair of the oppressive work as unjust hardness of the owners of the oil and gas in play for the reasonable to deprive of the economic of the West Virginia with the just benefit of the natural wealth of the state. 3. Of the greater proportion of the time, all of the such for the leaf of the other continue with the contract based upon the calling of the annual flat with well royalty would have been existing with a great many years of the way yes was entered into the time when the technique with which for the oil and gas currently extracted the produce of the market with what known if the contemplated with the parties not was with the contemplated with the parties the oil gas would recover and extract with the produce the market for the depth of the horizon currently have been developed by the well operators. 4. That while being fully cognizant of the provision Section 10 of the Article 1 of the United States Constitution, Section 4, Article 3 of the Constitution of West Virginia, prescribe the enactment of any of the law with impairing with the obligation contract with the legislature further find with the valid extra of the police over the powers of the state of the interest of the state of the West Virginia further earns of the welfare of the citizen and 2 of the district of the far as constitutionally possible the production, marketing of oil and gas located in state under the type of the lease of the continuing contracts described above. In light of the foregoing finding, the legislator hereby declare that the policy of the state would extend with the possible to prevent extraction, production, marketing of the oil, gas, use, the leases of the continuing contract provide flat well royalty, any of the same similar provision of the compensation owner of the oil and gas in place, which are inherently related to volume of oil and gas produced and marketed towards these ends. The legislature fully further declares the obligation of the state of the prohibited issuing with any of the permit required by the further development of oil and gas right, the development, extract, the produce, the market, and the same basis on such lease and other continuing contractual agreements. In addition, any of the requirements contained in the article with respect to issuing any of the permit required drilling, redrilling, with the WP fracturing, stimulating with the pressuring, diverting, with the combining, with the physically changing a line with the mitigation of the fluid with the one formation to another. No such permit shall be here of the issue unless lease or leases or the continuing contract with which where the extract with the producer of the marketing oil and gas filed with the application such permit in lieu of the filing lease for the lease or other continuing contracts applicant with the permit described herein may be the following: A brief description of the tract included with the district of the county wherein tract located, identification of all of the parties will leave the other continual contractual agreements which have the right to extract with the product mark of the oil and gas claim in the books of the page number the whereas in such leave of the contract by which right extract produce under marketing oil and gas recorded a brief description royalty provision each such lease of the contract unless provision subsection are not meant such permit herein issued with the drilling with a new oil and gas well with redrilling with deepening fracturing simulating pressuring verting combining physically changing all allowing the mitigation of fluid one formation to an existing oil and gas production well whether it's right to extract produce market oil gas based upon lease or leases other continuing contract provided with the flat well royalty any similar provision compensation owner of the oil and gas in place which inherently related to volume of oil and gas extracted the produce in the market. To avoid permanent prohibition, subsection D with the applicant may file with such of the application affidavit certified by the affiliate is authorized owner and working interest well of the state that shall attend with the owner and oil gas play for not less than 1/8 of the total amount paid to or received by or allowed to the owner working interest of the wellhead of the oil gas extracted the produce of the market before deducting the amount paid for the set aside of the owner and oil gas place that all such oil and gas to be extracted the production marketed from the well affidavit to be filed with such application, then such application permit should be treated with such a lease for the continuing contracts comply with the provision of the section. Owner of the oil and gas well placed in the shall cause the action of the enforcement owner's right within the establishment of the section. Provision of the section shall not apply any lease for the other continuing contracts underground storage of the gas, any of the well utilized connection with therewithin, otherwise subject with the provision Article 9 and chapter the director shall enforce the requirement irrespectively with the lease of the other continuing contract was executed. Provision of the section shall not adversely affect any of the rights of free gas. 2269 notice of the property owners no later than filing the application of the applicant with the permit any of the well work shall deliver the personal serve of the certified mail return receipt, requested copies of the application well plat and the erosion sediment control plan required with the section 6 of the article of the following person, the owner of the record surface of the tract with the well is ordered to be located with the owners of the records of the tract with the overlying oil and gas leasehold being developed with the proposal of the well work within such of the tract that utilize with the road to other land disturbances described in the erosion sediment with the control of the submitted with the pursuant 6 of the article. If more than 3/10 of the common of the co-owners inch of the direction, subsection A of the section hold interest such of the applicant with the make sure of the documents required for the upon the person described in the record shall share of the required for the maintain pursuant to the section 8 of the article 1 chapter 11A of this code published of the county well is located with the chapter class D with the legal advisement with the described of the 2 article 3 chapter 59 of this code contains such notice information ever the director shall prescribe with the fuel rule first publication date with the being with the 10 days filing prior to the filing of the permit application provided that all the owners occupying with the tracks well working proposed located following date of the permit application shall receive the actual serve of the documentation required subsection A of this section. Hurt material served on the person described in subsection A and B of this section shall contain the statements of methods of time limits filing claims of mini file my file comments for the name and address of the director, purpose of the filing, comments that pertain with additional information, statement, etc. of the person may request for the time submitting with the comments, notice of the permit, decision, a list of the person qualified, the test world as provided in section, any of the person entitled to submit with the comments with the ensure with the entitled to receive the copy of the permit, issue with the copy of the order denying with the permit, if such person requests the receipt thereof of the comments during said permit application. Person entitled to notice may contact the district office of the division, a certain name of the location of the water test laboratory for the applicable request of the qualified with the test of the water as supplied with the accordance with the sharing and accepted methods, including such list for the name of the division, consult with the chief of the Bureau of the Public Health and Local Health departments. 2610 procedure following comment certification of notice.